Jeszcze przyjdą inni chętni, to oczywiście w trakcie będą zajmować miejsce, ale już nie przedłużamy, już minęła 12, także chciałbym rozpocząć. Chciałem serdecznie powitać pana profesora Marka Godsey'a, który zgodził się, był tak łaskaw, zgodził się wygłosić dla państwa wykład, dla nas wszystkich wykład, który był Niesłuszne skazania i DNA, Ruch na rzecz reformy, wymiaru sprawiedliwości w USA i na świecie. Za chwilkę pozwolę sobie kilka słów jeszcze powiedzieć na temat osiągnięć pana profesora, kariery zawodowej, a teraz chcę jeszcze przedstawić pana Adama Bodnara, wiceprezesa Chrześcijańskiej Fundacji Praw Człowieka. Proszę państwa, jeśli państwo pozwolą, tak króciutko, żeby już nie zabierać za dużo czasu, żeby umożliwić panu profesorowi przeprowadzenie wykładu, na który wszyscy czekamy, kilka słów tylko na temat działalności pana profesora, projektu, którego jest autorem i na temat kariery zawodowej pana profesora. Otóż pan profesor Godsey jest jednym z wiodących nauczycieli akademickich w zakresie przesłuchań prowadzonych przez policję, także jest uznanym adwokatem i autorytetem w kwestiach dotyczących błędnych czy wadliwych błędnych skazań osób niewinnych. Profesor Mark Godsey był współzałożycielem, stoi na czele Ohio Innocent Project. Projekt profesora Godsey'a jest jednym z najbardziej aktywnych w całym kraju i dotychczas doprowadził do zwolnienia 14 skazanych, którzy okazali się niewinni. Najważniejsze sprawy z tych 14 skazań to wskażę tylko 4 sprawy. Pierwsza to jest grupa spraw pod nazwą Clarence Elkins. Tutaj są osoby uniewinnione w roku 2005 w oparciu o badania DNA. Byli skazani na dożywotnie więzienie za zabójstwo i zgwałcenie. Druga sprawa to jest sprawa Chris Bennett, zwolniony w roku 2006 na podstawie wyników badań DNA. Skazany był za zabicie w wypadku komunikacyjnym, pozbawienie życia w wypadku komunikacyjnym. Trzecia sprawa Robert McClendon, uwolniony na podstawie wyników również badań DNA po odbyciu 18 lat więzienia za zgwałcenie. Czwarta sprawa z tych takich najważniejszych, Raymond Towler, uniewinniony w wyniku badań DNA, zwolniony po 29 latach więzienia za przestępstwo zgwałcenia. Profesor Godsey i jego centrum zaproponowali szereg znaczących reform prawnych w stanie Ohio. Usilnie pracowali nad ich wdrożeniem w życie. Na przykład w roku 2010 gubernator pan Strickland podpisał Senat Bill 77, który spowodował, że stan Ohio stał się, można powiedzieć, modelowym stanem zmierzającym do ograniczania wadliwych skazań osób, błędnych skazań osób niewinnych. Od roku 2008 pan profesor Godsey był członkiem Rady Dyrektorów sieci Niewinność, organizacji reprezentującej projekt Niewinność w Stanach Zjednoczonych i na świecie. Pan profesor Godsey prowadzi wykłady, udziela konsultacji w Europie, w Afryce, w Azji, wspólnie ze swoimi asystentami, współpracownikami, starając się propagować mechanizm walki z błędnymi skazaniami osób niewinnych. Pan profesor Godsey jest też stałym komentatorem w sprawach karnych i odnośnie problemów związanych z wadliwymi skazaniami osób niewinnych w prasie lokalnej i ogólnokrajowej. Pojawia się także w znanych programach telewizyjnych, m.in. Larry King Live, w telewizji NBC, CNN, BBC i w innych również telewizjach i programach. Jeszcze na koniec krótko tylko o przebiegu kariery pana profesora. Pan profesor ukończył Morris College przy Uniwersytecie Stanowym w Ohio, gdzie pracował również jako redaktor Law Review. Pracował także dla prezesa sądów apelacyjnych okręgu Salt Lake City stanu Utah. Specjalizował się w procedurze cywilnej oraz w sprawach przestępstw urzędniczych w kancelariach adwokackich w Chicago i Nowym Jorku, gdzie pracował pro bono dla instytucji federalnych obrońców publicznych. Potem pan profesor Godsey pracował w Departamencie Sprawiedliwości jako asystent prokuratora Stanów Zjednoczonych dla południowego dystryktu Nowego Jorku, gdzie ścigał zbrodnie korupcji politycznej, zbrojnych napadów i generalnie przestępczości zorganizowanej. Jako prokurator federalny nadzorował śledztwa prowadzone przez FBI, oskarżał przed sądami, przedstawiał apelacje przed Sądem Apelacyjnym Stanów Zjednoczonych, otrzymał także szereg nagród za swoją działalność, m.in. od prokuratora generalnego Janeta. To tyle w skrócie o osiągnięciach pana profesora, o jego karierze zawodowej, co przybliży nas niewątpliwie do tematy wykładu. A jeszcze zanim udzielę panu profesorowi głosu, to poproszę pana prezesa Bodnara, żeby powiedział kilka słów na temat programu Niewinność Fundacji Krystowskiej. Bardzo proszę, panie prezesie.
Dziękuję bardzo za umożliwienie i za zorganizowanie tego wykładu przez Trybunał Konstytucyjny. Jak w imieniu Helsińskiej Fundacji Praw Człowieka chciałbym bardzo serdecznie podziękować. A swoją wypowiedź chciałbym rozpocząć w sposób dość nietypowy. A mianowicie, proszę Państwa, teraz w wypożyczalniach bądź w sklepach z filmami można kupić taki film The Wronged Man. Tłumaczenie polskie Niesłusznie skazany. To jest film, w którym główną rolę gra Julia Ormond, prawniczka, która przez 20 lat konsekwentnie zajmuje się jedną konkretną sprawą Clive'a Willisa, który został skazany za gwałt. I po tych kilkunastu latach takiego, powiedziałbym, bezsensownego prowadzenia sprawy, bezsensownego w takim sensie, że sądy nie odpowiadały w żaden sposób na jej liczne argumenty wskazujące na braki w materiale dowodowym, ona wykonuje telefon do instytucji, która się właśnie nazywa Project Innocence. I pomoc, która jest zapewniona przez Project Innocence, czyli możliwość przeprowadzenia badań DNA, okazują się przełomowe i na koniec pan Clive Willis wychodzi z więzienia w stanie Luizjany. Chciałbym powiedzieć, że w Fundacji Helsińskiej my mamy taką właśnie Julię Ormond, którą jest Maria Eichhardt, która od 1999 roku prowadzi w Fundacji program, który się nazywa Klinika Prawa Niewinność, w którym właśnie się zajmuje tymi przypadkami, jak my to nazywamy, jest to program spraw beznadziejnych, tak? Czyli program spraw, w których różne osoby zostały skazane, bądź też są naszym zdaniem niesłusznie oskarżane i poprzez podejmowanie różnego rodzaju działań procesowych, poprzez zadawanie pytań, pani Maria Eichhardt razem ze współpracującymi studentami prawa oraz studentami Instytutu Profilaktyki Społecznej i Resocjalizacji UW stara się jakby doprowadzić do tego, żeby coś z tą sprawą zrobić. Takim mottem tego programu Klinika Prawa Niewinność są słowa profesor Łętowskiej, że sprawowanie wymiaru sprawiedliwości oznacza, że zawsze muszą się zdarzać błędy, że błędy są nieuniknione. I to, co my staramy się w tym programie robić, to właśnie wyłapywać te błędy i właśnie dzięki aktywnej pracy Marii Eichhardt doprowadzać do tego, że niektóre osoby są w efekcie jej działań uniewinniane, bądź też postępowania są umarzane. I to, na co mamy dużą nadzieję i temu ten wykład także służy, to chcielibyśmy także dzięki wsparciu właśnie tej wiedzy amerykańskiej doprowadzić do tego, że badania DNA zaczną być wykorzystywane na szerszą skalę w polskim wymiarze sprawiedliwości, gdyż uznajemy, że być może to jest jeden ze sposobów na to, aby właśnie doprowadzić do sprawiedliwości, czyli do wypuszczenia z więzień osób, które zostały niesłusznie skazane. Ten przypadek, o którym mówiłem, przypadek Clive'a Willisa z 2003 roku, to był 138 przypadek w historii Stanów Zjednoczonych, kiedy przy wykorzystaniu badań DNA uniewinniono osobę. Od tego czasu, jak podejrzewam, jest o wiele więcej takich przypadków, ale może na tym chciałbym przerwać i oddać głos naszemu szanowemu profesorowi, który przedstawi nam, jak właśnie ta praktyka wygląda w Stanach Zjednoczonych. Dziękuję bardzo.
Thank you very much for having me here. It's a big honor to be able to come and speak to you today. And I want to thank the Helsinki Foundation and Constitutional Court and Maria Eichhardt in particular for hosting this and putting this together. What I'm going to do is talk about the innocence movement in the United States, how it originated, how it has evolved over the past 20 years. I'm going to talk about it specifically with respect to my state, the state of Ohio. Ohio is sort of in the middle of the United States. If you can picture where the Great Lakes are, around that region, sort of close to Chicago. I'm going to talk about our efforts there. Then I'm going to talk about what the innocence movement has taught us about the criminal justice system in the United States. Indeed, I think it's actually taught us quite a bit about human nature. But before I do, I'm going to start off with a short video. This video is about 5 minutes long. It is the trailer of a longer documentary film. And it shows the students in our Innocence Project working on a particular case And it goes into a little bit about this case of Clarence Elkins, who we exonerated in 2005. And later in my lecture, I'm going to come back and describe this case in a lot more detail. So I think this will sort of set the stage and give you the flavor for that case and the kind of work we do. I'm Marka Godsey'a. I'm a law professor here at the University of Cincinnati College of Law and director of the Ohio Innocence Project. Our mission is to look at old cases where the inmates steadfastly maintain their innocence from the beginning to the end, and see if there's some sort of evidence, new evidence, that might be able to shed light on it.
The brother and the sister don't really get along, but
The Innocence Projects use law students to investigate the cases of people who claim they're innocent and look into DNA testing and other technologies. So it's a real hands-on experience for the students.
they like Bill for this crime from the very start. He has priors, assault, hardcore drug convictions.
My name is Michelle Berry. I'm a third-year student here at UC Law School, and the reason I came to UC Law School actually was because of the Ohio Innocence Project.
The simple mission is to get innocent people out of prison.
It's one of the greatest feelings in the world, knowing that you're helping someone who really needs your help and is actually innocent.
We definitely get tons and tons of letters. I mean, just last year I think we had about 500.
You take everyone who's written in and says, I'm innocent, please help me. The first thing that happens is you determine whether this is a case where DNA could actually prove you innocent, where there was a type of crime where DNA would have been left. 75% of those cases, the answer is no.
So there's a lot that's wrong with the case. There's not a whole lot of exculpatory evidence.
Some people see me as a defense attorney. I don't see myself as a defense attorney at all. I only go forward, we only go forward when we think the evidence proves they're innocent.
Read Clarence down! 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 Read Clarence down!
My name is Clarence Elkins. I was falsely accused and wrongly convicted for something I had nothing to do with.
Well, right now we're getting ready to go to the Attorney General's press conference, so I think this would be the best Christmas present that any of us could ever ask for. I'm feeling it now, just nervous.
A few minutes before our press conference starts, we get a call from them telling us that they've agreed, they're going to be announcing it there, that Clarence is innocent, he's going to be released. Jim Petro, Attorney General, just came in and announced that Summit County is holding a press conference at the same time as ours, and they're going to announce that they're just dropping all charges against Clarence. It's his immediate release.
We commenced to calling you in today to kind of make another announcement. We were announcing the completion of scientific testing by criminologists.
Yeah, he's been exonerated, they dropped all the charges, and he's getting out late this afternoon. Okay, very good.
Okay, well, I need to run because of
Dinner?
yeah,
Hey, Clarence, how you doing, honey? You okay? You ready to come home? Then get your stuff packed, honey, because you're coming home today.
I'm very proud of everyone who stepped forward on my behalf for justice.
This is Uncle Woody's. It's a bar right across the street from the law school where it's kind of the local watering hole for the law students that help us celebrate things. Here today celebrating Clarence Elkins' case. It's the first time we've got together since he got out.
It's an inspiration that I know that I'm going to carry with me throughout my career. Knowing that I'm picking up these skills and gaining this knowledge, and I'm able to use that to help people who can't do it on their own and have no other resort.
I just know that's what I'm meant to do.
Do I think the justice system is this, beautiful thing that we learn about in sixth grade social studies class? Absolutely not. But do I believe in justice? Absolutely. The criminal justice system isn't perfect, but if you fight hard enough and you have a lot of people on your side, you can eventually win.
All right, you guys, let's have a toast to all the hard work that all of you guys have done, not only the Elkins case, but all the other cases. Great result, and to Clarence.
Yes!
I've been sitting here trying to find myself. I get behind myself. I need to rewind myself.
We're in Magnolia, Ohio, where I used to live 7.5 years ago. I had approximately 4 acres. Used to hunt in all these woods here. It just brings back a lot of memories being here. And this was home. This was home 7.5 years ago. It was all taken in an instant. It's very difficult, very sad at times that it's not like it used to be, but at the same time, I got to move on, and that's our goal, is to move on and try to rebuild our lives.
How do I stop it? Okay, so if you go back in America before we had DNA testing, 1940s, 1950s, 1960s, 70s, etc., a system was in place, a legal structure was in place where inmates who claimed innocence, people in prison saying, I didn't do it. We all know those people who are screaming year after year, I didn't do this, I didn't commit this crime. There was a legal mechanism for them to reapply to the court. But usually, they were rejected, these claims were rejected, and you would see in these judicial opinions, when the judges wrote the opinions, a sort of arrogance about the system. Comments that, we have constitutional protections, the jury can't convict unless there's proof beyond a reasonable doubt. We have all these other protections like the right to an attorney and Miranda warnings and ban on torture during interrogations, etc., etc. So the system gets it right most of the time. And this sort of arrogance pervaded until the early 90s, and then along came the advent of DNA testing, which sort of turned the criminal justice system upside down, almost by accident, because if it had not been for two things. One, that some police departments had saved DNA from old cases. So there were people in prison 15, 20, 30 years, and the DNA from the case still existed. The fact that we had the DNA, and now, secondly, we had the ability to test it. That has been like a crystal ball that's opened up this new understanding about the criminal justice system, which I'm going to explain. So how the innocence movement started. There was a professor at a law school in New York named Barry Scheck, and he ran a law clinic. A law clinic is where law students, I know you have them here, law students get to work on cases to get practice while they're still in law school. And in the United States, they often represent poor people on very minor crimes, parking, traffic violations, very minor things, to get experience, and in that way, the indigent person gets representation at the same time. So Barry Scheck ran this indigent clinic with his students. Before this, though, back in the 70s, he'd been a public defender in the Bronx of New York, and he'd had a client convicted of rape. And he had always believed in his heart that this man was innocent. He'd been in prison now for many years, and it bothered him at night, and he always believed he was innocent. In the early 90s, Barry Scheck read about this new technology being used in the United Kingdom, DNA testing, and it was being used by prosecutors to help solve crimes. And it occurred to him that if he could go back and find that evidence in that old case of his, he remembered that the victim who was raped had gone to the hospital and they'd taken a rape kit with semen from the attacker. And he said, if by some chance that still exists and I can find that, I might be able to use this new technology, this DNA technology, to see once and for all whether he really is innocent, as I believe. He had his students investigate and look in, and they were actually able, very luckily, they were able to find that evidence. It had not been thrown away by pure chance. They sent it to the United Kingdom and got it tested for DNA, and it came back and proved his client innocent. This man had been in prison at this point for 14 years, and the courts let him go. This got nationwide attention. And so then inmates around the United States started writing to Barry Scheck and his students, saying, "I'm innocent too, test my DNA, please," and begging, and they started getting thousands of letters. So here he is, this group of 20 students who are doing parking tickets and traffic violations, and now they're looking into cases in Texas of people on death row. And just almost by accident, they had been converted into the very first Innocence Project. Within a few years, by the mid-1990s, they had exonerated 75 people across the United States by DNA testing. 1/3 of those were on death row. So this continued to expand throughout the 1990s. Other law schools started following this model. Law professors and law students, as you saw in the video that we have, started opening up Innocence Projects and looking into these old cases. Now in the United States, nearly every state has an Innocence Project, and they're spreading all across the world. There's Innocence Projects that started just in the last several months in the Netherlands and France. I'm going to help start one in China this summer. There's 2 in Africa. One's getting ready to get started in Mexico. They're all over in the UK and Australia and English-speaking countries. But if you look just at the United States, these law school Innocence Projects to date have exonerated almost 300 people by DNA testing. And now, because we've seen these systematic problems in the criminal justice system, we've started moving into other cases where there's not DNA. And I'll explain that a little bit later, but if you look at all the DNA and non-DNA cases together, the Innocence Projects have freed more than 500 people. Now, most of these are in prison for very serious crimes, rape and murder, life sentences, 25 years, or death row, very serious crimes. We don't even have enough time or resources to get into the lesser crimes. So, some people in the United States have looked at this movement, and the reaction has been, well, you've only proven 500 people innocent, but the United States is a huge country, and tens of thousands of people have been wrongfully convicted. Tens of thousands of people are convicted every year. So over 20 years, you've only proven 500 people innocent. That is a very, very small percentage of the people who are convicted of crimes. We know that the 500 we've identified is just the tip of the iceberg. I don't know the number of innocent people or the percentage of innocent people in prison, but we know that this is the tip of the iceberg. And I'm going to show you how we know that. If you take the thousands and tens of thousands of people who have written Innocence Projects, so these are not all inmates, these are just the people who have written to Innocence Projects across the United States. And if you say, my hands right here represents this, that's the number of people. The first thing the students do is they investigate the basic facts of the case to determine if it's a DNA case. So if somebody shot me through that glass with a gun and took off running, there's no DNA of the perpetrator here at the scene. And the vast majority of crimes, there's simply not DNA. DNA can't answer the question as to who the perpetrator is. It's usually only in rape cases where the rapist leaves semen, or like in a murder case where there's a struggle, and so the victim will have the perpetrator's DNA under his or her fingernails, or other cases like that where you can actually resolve the dispute by DNA. So the students get those basic facts, and they determine whether it's a case where DNA could prove innocence. Of all the people writing to Innocence Project saying, I'm innocent, about 90% of the cases are not DNA cases. So we're already down to a small sliver. Now, here's the ones where we look at it and we can say, okay, this was a rape and the victim was taken to a hospital, semen was collected, or there was a struggle, it was a murder. In these percentage of cases, the next thing the students do is they start trying to find the DNA evidence. Many of these cases are 15, 20, 25, 30 years old. About 75% of the time, the police have thrown away the DNA. Until recently in the United States, there were no laws requiring them to keep the DNA. So it was purely a matter of luck. In essence, if the police officer in charge of your case was too lazy to throw away the file when the case was convicted, when the case was finished, then you were lucky enough 25 years later to still have that box sitting in a property room, storage room somewhere. So here's the number of people saying I'm innocent. Only 10% of them have DNA in their cases. Only 25% of those, we can find the DNA. And the 300 and some DNA exonerations in the United States come out of that little tiny sliver. Okay? Of this little sliver of people who are fortunate enough to have DNA testing in their cases, about 50% of the time, half of the time, the DNA testing comes back and proves they're guilty. The DNA from the crime scene matches them. And I've had numerous of my own clients where that happens, and I always tell my students that's the best result we can possibly ask for. Because that means the real perpetrator hasn't been out committing more crimes. It shows the system did it right. That's what we should hope happens. About 25% of the time, it's inconclusive. So the lab comes back and says, it's been too many years sitting on the shelf, we can't get a result. But 25% of the time, roughly, in these little sliver of cases that are lucky enough to get testing, it proves the person innocent. Now the important thing to recognize is, of this little sample that gets tested, where we've had 300 DNA exonerations, the 300 are the 25% that are proven innocent. But there's no difference between the people here and all these other people writing to innocence projects, except that these people out here are not lucky enough to have DNA in their cases. And a lot of these people are on death row around the United States. Does this mean that I think 25% of people in prison are innocent? Absolutely not. Because we're dealing with a sample, a control sample, of people who write to innocence projects. And to write to an innocence project, you have to fill out a 23-page questionnaire. It takes a lot of work. I mean, there's a myth that everybody in prison claims innocent, but very few people actually take the time and go that far to write to an innocence project. But if there's been somebody in prison for many years screaming that they're innocent, and really putting a lot of effort into it, 5, 10, 15, 20 years later, our experience has shown us there's a decent chance, at least a 25% chance, that that person might actually be innocent. So, in Ohio, which is my state, I'm a professor at the University of Cincinnati Law School, and I run the Ohio Innocence Project, as you saw. We have 20 law students that work on cases at a time. We started in 2003, and since 2003, we've had 6,000 inmates in Ohio write to us. And we've investigated every single case. Now, the vast majority of them, you can tell there's nothing you can do with the case from the very beginning. And the vast majority of them are clearly guilty once we start to examine and look further into the case. And we start with the presumption that they are guilty. You know, we start with that presumption in our mind, and we're sort of having to overcome that presumption. But we've gone to court, out of 6,000 people who have written this, we've gone to court and taken the position that someone's innocent 24 times. And so far we've won 15 of them. Several more of them are pending. So, as you can imagine, you have this system in the United States which, through the 1970s, 1980s, we have a structure in place that if someone's in prison and they're innocent, it'll be very easy for them to vindicate themselves. But our system has all these constitutional protections. We don't really make mistakes very often. This sort of arrogance about the system. And then all of a sudden, by luck, because DNA testing came along, we find out that that's completely false. That there's a lot of mistakes being made. And a lot of these people in prison screaming they're innocent actually are innocent. So as you can imagine, social scientists have begun studying these cases and studying the phenomenon of wrongful conviction to say, what went wrong in these cases? And can we learn something from this experience to improve the criminal justice system, to make it better, to make it more accurate? And that's what I'm going to talk about next. The number one thing that jumped out at social scientists who studied these cases, 75% of the convictions occurred because of eyewitness identification, mistaken eyewitness identification. And these are generally the rape victim, the innocent person, bystander, who saw the murder and saw the murderer run from the scene, or saw the robber run from the store. Somebody without a motive to lie, who's coming in and trying to do the best job they can. And they identify someone, but they're simply wrong. In some of the cases, up to 10 different people identified the perpetrator, who ended up being innocent. 10 different people looked at a six-pack, 6 photos, and said, that's the guy. They picked number 2. And then in the courtroom later, they picked the man in the defendant's chair and said, I'm sure that's him. But DNA testing proved them completely wrong. So this has spawned a lot of scientific studies about eyewitness identification, and it's really been shocking what we've learned. We've learned that memory is not nearly as reliable as we intuitively believe it to be, and that eyewitness identification, particularly people who are completely positive, that's the man, I'll never forget that face, not nearly as reliable as you would expect. And there have been study after studies done in the United States where they'll have a room full of people just like this who are coming to hear a lecture. And you'll have somebody walk in like this, walk up beside me and shoot me with a gun, a fake gun. And then the person will walk slowly back and look at the crowd so everybody gets a good chance to look at his face. And then I'm not dead, I jump up and I say, surprise, we're going to do a study. And everybody in the audience is divided into different groups. And in each group they do the eyewitness identification in a different way. In some of the studies, they have 6 photographs for the witnesses to look at. But none of them are the man who walked in. None of them are the man who walked in. So this is setting up a situation where the police have a suspect, but they are incorrect about their hunch. This is where wrongful convictions happen. We find that about 60% of the time, the audience picks someone. Even though the right person is not there, even though they got a good chance to look at his face in an extended period of time. And in fact, many of these people end up being very positive. They state with confidence, yes, it's number 3, and I'm sure of it. We did a lot of other things and changed the studies around to show some other problems in the system. For example, in some of the groups, when the person makes a pick, the officer who's giving the photo lineup to the witness is instructed to say, yes, that's the guy who did it. In another group, the officer is instructed to say that we think that's the guy who did it. In a third, they just sort of nod like this. And in a fourth, the officer doesn't know which one they're supposed to pick. He's blinded. We found that in the groups where the officer said, yes, you got the right person, or we think you got the right person, when those individuals are asked, how confident are you in your pick, the confidence level is much higher. It's up in the 90s. In the groups where the officer gave no confirmatory feedback, the confidence level is in the 60s. But the interesting thing is, all the witnesses are asked, was your confidence level influenced at all by the officer's feedback? And they all almost universally say, absolutely not. But it's clear what we're doing is, we've learned from this, that when the officers, I did this as a prosecutor, because I didn't know it was wrong. But when the officers say, we think you picked the right person, they're contaminating the evidence. They're taking shaky evidence, which is not that reliable, and turning it into very confident, 100% reliable, and that's often where the wrongful convictions happen. Another thing we learn from all these studies is that if the officer shows the photographs to the witness, to the eyewitness, one at a time, here's number 1, take it away. Here's number 2, take it away. Here's number 3, on and on. The accuracy level is much higher. They're much less likely to pick an incorrect person, to pick an innocent person, and they're slightly more likely to pick the person who actually walked in the room. And so the question becomes, why is this the case? Social scientists, psychologists believe that when you're shown all the photos together, like how it was traditionally done in the United States, the person's mind makes a relative judgment, and they end up picking the person who looks the most like the perpetrator. Which explains why, when they had somebody walk in these studies and walk out, and that person's picture was not in the photo spread, 60% of the people still selected someone because they did a relative judgment in their mind, and they picked the one photo that looked most like the perpetrator. But if you show them one at a time, and the individual who committed the crime is not one of the 6, they're very unlikely to make a selection. But when the person who committed the crime is in the 6, they're slightly more accurate than when you show them all at the same time. Okay, so just that one simple thing has caused this reform in the United States, where now states are passing laws requiring that the photos be shown one at a time, and that the officer who shows the photos to the victim or the eyewitness be blinded. The officer doesn't know which one of the 6 is a suspect, so there can be no confirmatory feedback. It's not only being tough on crime because it actually improves your ability to get bad guys off the street. It's smart on crime. Because every time you convict the wrong person, there's somebody else committing more crimes. And these Innocence Project exonerations we discussed, the 300 cases, 40% of the time the Innocence Projects help identify the right perpetrator, the guy who actually did it through DNA. And many additional murders, etc., were committed in the meantime. So I want to talk for a minute about the Clarence Elkins case that you saw on the board. and just to give you an example, an illustration of one particular case and how it played out. In this case, the crime occurred in 1998, and a grandmother, Judy Johnson, had her home broken into in the middle of the night by a male intruder. And the male intruder came in and raped and killed her. It was a very brutal killing. And unfortunately, her 6-year-old granddaughter was spending the night with her that night. And during the attack, which must have been very loud, the granddaughter opened the bedroom door and looked out and saw. And the perpetrator apparently saw her. Because a few minutes later, after the grandmother had been murdered, the perpetrator came, knocked her unconscious, and then raped her. When she awoke in the morning, she identified, she said the perpetrator was her uncle Clarence Elkins. Within a few hours, the police had arrested Clarence, and the thought was, how can a girl get her own uncle wrong? Right? If she's identified her own uncle, who she sees all the time, she must be right. Now, it was pretty clear that she was under great stress at the time. It was very traumatic. The room was dark, and she's only 6 years old. But that's the evidence they had, and they latched onto it, and they brought him to trial and actually sought the death penalty. The jury convicted. They did not return the death penalty. They gave him life in prison. We got involved in 2004. And by this time, DNA testing had advanced greatly, even from the time of 1998, when the crime occurred. And we got the rape kit from the coroner, the one who had examined the grandmother, Judy Johnson. And the coroner had taken vaginal swabs from her vaginal cavity. We did DNA testing, and we were able to find male DNA in her vaginal cavity that was not Clarence Elkins. It did not match Clarence Elkins. We then examined the evidence of the girl, Brooke Sutton. We didn't find any male DNA on her body, but we know that as the facts occurred, the man knocked her unconscious and went like this and removed her underwear. So we looked for male skin cells on either side of the elastic band, and we were able to find male skin cells right there where we expected them to be. That also did not match Clarence Elkins. But more interestingly, the male DNA from the grandmother's vaginal cavity matched. It was the same man from the DNA on the little girl's underwear. All right, so what does that tell you at that point? That's got to be the perpetrator, right? The only man whose DNA could be in both of those locations on both victims on that night would be the person who committed the crime. And we had DNA tests showing that it was not Clarence Elkins. You saw in the video that we were protesting outside the prosecutor's office. That's because we went and presented that evidence to the prosecutors and asked them to release Clarence, and they refused. And they came up with all these very far-fetched theories. It was very clear that they just were absolutely convinced in their minds that Clarence was innocent, and they had lost all sense of neutrality and objectivity. In fact, the actual prosecutor, when we went and met with him, he's the one who had convicted Clarence, had done the trial many years before, and he had framed on his wall the front page of the newspaper when he won that trial and Clarence was convicted. And so it was right there on the wall while we're presenting this evidence. And he was just absolutely, no way, Clarence is absolutely guilty. There's some trick somewhere, etc., was his argument. We presented it to court, and we lost. The judges had the same mentality. Tunnel vision. Tunnel vision. I mean, they're so used to getting it right, and they think, and they do get it right so many times, vast majority of the times, that it's very hard for human beings to accept later that a mistake's been made. What happened was, interestingly, the blonde woman, his wife, Clarence's wife, Melinda, that was her mother who had been murdered. Judy Johnson was her mother. And she knew all along that Clarence was innocent because Clarence was with her when the crime occurred. But the prosecutors impeached her on the stand and said she was lying just to protect her husband. But she knew Clarence was innocent, and she wanted to find the person who killed her mother. So she was investigating herself because the police refused to help her. The police thought they had solved the crime. She'd been going out and meeting men, shady-looking men, and men who had criminal pasts from her neighborhood, meeting them in bars, and then walking away with their cigarette butts and beer bottles, so that eventually she could save enough money and do DNA testing to try to prove who killed her mother. After we lost that case, Melinda saw in the paper that a man had been convicted of child molestation, and he lived next door to the house where her mother lived when she was murdered. And so we got on the computer And we saw that this man had a long criminal past, but he was out of prison for a short window of time right when the murder occurred. He had gotten out about 7 days before the murder and picked up for another crime about 6 days after. The fascinating thing was the man was now in prison, and out of 33 prisons in Ohio, he was in the same prison with Clarence Elkins. So when we told this story to Clarence, Clarence was able, it took him about a month, he followed the man around, he was able to pick up a cigarette butt and flatten it down in a book, put it in an envelope and mail it to us. And we sent it to the lab, and it came back and it matched the DNA from the crime scene. It matched the DNA from the vaginal cavity of the grandmother and the underwear of the little girl. So what did the prosecutors say? That can't be that man's cigarette butt. How do we know this is reliable? So we got a court order to take his blood, and it did come back and in fact match. And we finally, on December 15th of 2005, about a year after we had the first DNA results proving him innocent, we finally walked him out of prison. Earl Mann, the individual who committed the crime, later pled guilty and is serving a life sentence for those same crimes. That's just one case. Raymond Taller, one of our most recent exonerations, 29 years in prison. 3 different people, including 2 adults, who saw the perpetrator in broad daylight, identified him as the rapist, as the man who took the little kids into the woods. DNA testing, we were so lucky, after 29 years we found some of the evidence that remained in the case. Very, very lucky. And he walked out of prison about 2 years ago, after 29 years. Amazing man. But all of these cases have stories like this. But if not for this, we would not have learned about the problems with eyewitness identification and the ways to reform the system. We've learned about false confessions because a great number of these people actually confessed during the interrogations, even though no torture was used, and they were given Miranda warnings, a right to an attorney, a right to remain silent, etc., etc. And this just sort of blew people's minds. Why would somebody confess to a crime they didn't commit? And so now psychologists have studied these people who falsely confessed, and they've come up with different explanations. And we understand that it occurs much more often than we would ever imagine. We've also learned that you can see the earmarks or the signs of a false confession if it's videotaped. Because in some of these cases, they had videotaped the confession. Now, looking back with a new light, you know the person's innocent, you can start to see where the interrogation went wrong and how the officer was feeding facts about the case to the person without even realizing he was giving them facts. And then the person would confess and repeat those facts back. So the states have started passing laws requiring that interrogations be videotaped. So now we can go back. And this is good for police and prosecutors because they have the videotape they have the confession on tape. In the vast majority of cases, which are valid, solid confessions, it makes the case much easier to prosecute. But we have a clean record. If someone's claiming, I falsely confessed, we can have experts examine it to give that opinion. I'm going to touch on a couple other things real quickly, then I'll take questions. Another thing that we've learned, you know, the way that the courts and prosecutors have reacted was very surprising. And a term in the United States, tunnel vision, has been used to describe how many of the prosecutors and police and judges are so invested in the system and they believe so deeply in it, and it is a good system, that they have trouble being objective and listening to the facts with an open mind when new evidence is brought to them 15, 20 years later. Just like I described in the Clarence Elkins case. And it's happened repeatedly, over and over and over again, where an innocence project has proven someone innocent, and the prosecutors don't believe it. It's happened so much that now there's psychological studies about tunnel vision. There's been books that have been published. And some of the more progressive, open-minded prosecutors' offices have tried to institute training and structures to encourage the prosecutors to be open-minded and be concerned about justice rather than just defending the conviction. Making sure that they're always open to the possibility that they might have made a mistake. I don't think that's unique to prosecutors or judges or the criminal justice system. I think that's human nature. That it's, you know, we give ourselves too much credit for our ability to be open-minded later when new evidence is presented. And I think that's one thing that the Innocence Project, the Innocence Movement, has also shown us. A final thing I want to touch on before I take questions. A lot of these people we went back and examined the cases, were convicted on what we now know is junk science. Somebody, before we had DNA, some CSI expert took the hair from the crime scene and put it under a microscope, took the suspect's hair and put it under a microscope, and then came to court and testified that they matched, that they came from the same person. Now we've gone back and tested the hairs in those cases, and we know that's complete junk. About 50% of the time, those microscopic hair matches are completely wrong, because now we can actually see the DNA profiles inside those hairs. There's been people, this has spawned an inquiry into all other types of science. For example, in the 70s and 80s and 90s, a lot of people were convicted in the United States and in other parts of the world based on fire science, arson. A house would burn down, somebody would die, and only one person was present who survived. And they would have an expert come and look at all the burns on the walls and the ceilings and the floor. And there was a science, they believed that if the burn showed a certain pattern, that meant that gasoline had been used. It was an intentional fire. So we had all these people convicted because they were the only ones who could have said it, and experts said it had to be said intentionally because of the burn patterns. Later, someone decided to do a bunch of experiments in old abandoned houses, and we learned that those same patterns appear all the time when the fires are set accidentally, when there's no accelerants used. So we've determined that that science that sent hundreds of people to prison is completely invalid. Gunshot residue. People were convicted because there was a shooting, and the police would come and interview everyone, and they would swab their hands and who were in the vicinity, and one person would be found to have had gunshot residue on their hands, which means they fired a gun earlier that day, and that would be very damning evidence that was used to convict them. Later, after the innocence movement, we started realizing the weaknesses in some of these sciences. Some other scientists started looking into that technology, and they learned that if you're driving a car and you put the brakes, those same materials come through the vents and get on your hands. They also learned that police departments and police cars are completely covered with gunshot residue, GSR, because police officers have to do gun training all the time. And so they went in and they tested the seats in the back seat of police cars, and they had people handcuffed and sit in the back of the police cars, and they got gunshot residue from being handcuffed in a police car, because it's all over the seats. And so I have several clients who were convicted because they were handcuffed and taken to the police station in a police car, and we now know that they've got a better than 50% chance of getting gunshot residue on their hands simply because of where they were, or they may have been driving a car that day. So as you can see, there's a lot that we've learned from this, and it's really sort of causing a lot of reform. And now at this point, it's actually starting to spread around the world. There's a lot of other countries that are interested in these reforms as well. So at this point, I see we only have about 10 minutes left. I'd be happy to take some questions. Yeah?
Do I need the mic? I want to...
Yeah.
And I have a translation, so if anybody wants to ask in Polish, I can listen and answer the questions as well.
So I wanted to address several issues. First, I want to ask about the conclusion. If there's any a general conclusion you would draw from your research, because the impression I get from listening to what you said is that this human factor included in the investigations is so flawless that it should be reduced as much as possible. But it's an extreme, I understand, and maybe we should only rely on the scientific methods. But then again, another level comes, and then you see that the human factor is also included in those scientific methods, that those tests are also performed by human beings, and so that's the second issue I want to ask you about.
Let me answer that, then we'll move on. I think, to me, the biggest lesson is the lesson to be open-minded, because we're never going to have a perfect system. We can't throw up our hands and say there's flaws, so let's just let all criminals go free. Right? We have to use eyewitness identification, because if not, so many murders are occurred, and that's the only evidence. You have to still try to get confessions from people who are guilty. we have to go forward, but the problem is we have to be humble enough to recognize the weaknesses so that we, in the end, are concerned about justice. We're open to hearing when something that happened earlier might be flawed. So that's the main thing, is just being open. As far as the forensics and sciences go, I think it's also taught us that, you know, we can't just say, oh, we'll never use forensics, we'll never use science because in 20 years there might be a better method that shows us what we did today is invalid. But we have to be aware of what we've learned from the innocence movement and try to be as careful as possible. And try to make sure that, you know, we ask as many questions about the science before we allow it to come in.
So maybe the last thing, do you have any doubts ever about the tests, the DNA tests? To what extent does any margin of mistake exist in this particular science? I'm not referring to the DNA itself, but mainly to the human factor included in it, to the labs or people who perform these tests. Does it ever come out in your work?
Yeah, I mean, anytime you have human beings involved in the process, there can be mistakes. So even with DNA, I think it's important to try to separate samples. For example, if we have a sample, we'll take one piece and have it tested by one lab, and the prosecutors will then usually take another piece and have it tested by another lab, so that you're verifying the results. The National Academy of Sciences, which is a government organization in the United States, because of all these problems that have arisen, they did a multi-year investigation and published a report in 2009 on the state of forensic sciences. It's a 500-page report. If anybody wants it, you can email me, and there's executive summaries which are much shorter. It's fascinating. But they go through all the different forensic sciences that are used. They do say that DNA is the most reliable, and partially because it's been developed later with all the scientific methods that we're using. Like things like microscopic hair comparison. People started doing that 100 years ago, before we had the procedures in court to really test science. But they go through and explain that DNA is the most reliable, but you always have to be careful with it. Yes, in the back.
How expensive is it since the woman has to save money?
It gets less expensive all the time. If there's a case where all you have to test is, say, semen from a rape kit, and then you have to test the man who's in prison, you have to get a swab from his mouth. The semen may cost about $600, and the swab from his mouth may cost about $600. So that's $1,200 would be the cheapest. But in the Clarence Elkins case, there were many vaginal swabs from the grandmother. And we tested the first one and got nothing. We tested the second one, got nothing. Tested the third one and we found male DNA. So we already had one expenditure, second expenditure, third. And then we tested her fingernails. 600, 600, 600, 600. And then the little girl, we tested the vaginal swabs, nothing, nothing, nothing. Until we got to the underwear. We finally found male DNA on the underwear. So she raised money and we also spent some of our own money. But that case cost about $20,000 to $30,000 in DNA testing. That is at the high end. Most cases are not that expensive. Yeah.
Maybe it's beside the topic, but I wanted to ask you a question with regard to damages that can be claimed from, I don't know, the state?
Yeah.
And if so, what kind of damages can be claimed?
If you take the 300 people, almost 300 that have been exonerated by DNA, I think about half of them have been compensated. It depends on what state you're in the United States. Some states are very good about that. Other states are not good about it. Clarence Elkins received about $6 million.
How many years was he in prison?
7.5. He has 4 houses now, and several boats, and he lives a very nice. He was very depressed for several years. Very depressed after he got out of prison. It took a lot to get him, but now he's finally reestablished. He's lucky on the end of compensation. Raymond Tyler, the man who spent 29 years in prison, got $6 million as well. But there's many people who've gotten no.
Explain the basis. But basically, so you go through a normal procedure where you have to go to court and.
Yeah, I'll explain the procedure. The states have to pass compensation statutes, and about half the states have compensation statutes. So the legislature passes a bill that says if you're proven innocent, you will get X amount per year, a certain amount per year that you were wrongfully convicted. And if you're in a state that does not have one of those, then you usually do not get compensation. But if you're in a state that does have compensation, you can collect that statutory compensation. Now, if your case was one that involved intentional police misconduct, Clarence Elkins's involved misconduct that was later discovered because the man who committed the crime, it turns out that when Clarence Elkins was awaiting trial, that man was arrested. When he was arrested, he said to the officer, "Why aren't you arresting me for the murder of Judy Johnson?" And he gave a confession. And the man wrote it, the police officer wrote it in a memo and sent it to the police officers investigating Clarence's case. And it disappeared. And under the U.S. Constitution, those police officers were required to give that to Clarence's attorneys. And so when that was discovered, Clarence could sue in federal court for damages based on the intentional misconduct. Maybe 1 in 5 cases has intentional misconduct. But that's the reason why Clarence got so much money. See, Raymond Tyler was 29 years, and he got $6 million. Clarence Elkins was 7.5 years, and he got $6 million. But Clarence is involved in intentional misconduct. Is why he got more. But I mean, there are many people who have spent 20 years in prison who are proven innocent by DNA in the United States, and they're destitute right now. And they're in deep depressions, and they haven't been able to get compensation. So they either are in a state without a statute, or they have a judge who's very close-minded.
But, so if a state does not have a compensation statute, then you cannot go to a regular court to...
Only if you have police misconduct. Maybe the 1 in 5 cases that have police misconduct.
I would like to ask about the Alford plea. Have you been offered Alford plea in any of your cases? If so, have you accepted it, and what was the result?
Yes. 2 of our clients, the mechanism, the way it works in the United States, when you have new evidence showing innocence, the conviction is overturned, but the prosecutor can choose to retry the person. Now, normally the prosecutor says, well, DNA has proven them innocent, so I'm going to let them go. If I tried to go to trial, I would lose. But in a few of the cases, the prosecutors have tried to retry them, and which means the person had to stay in prison until the trial. And so one of our clients was so depressed, and it was going to be 6 more months in jail until his trial, that when they offered him a plea to a lesser charge, they said, if you plead guilty to a lesser charge, we'll let you walk free today. And he took it, even though he was innocent. Another one of our clients did the same thing about a month ago, where the conviction for murder was overturned, and the prosecutor said that, oh, we're going to retry you in 6 months, so you have to stay in jail. But if you plead guilty to a lesser offense, we'll let you out today. And he took the deal and walked away. Even though he was innocent, he took the deal and went home, which is very frustrating. And when they do that, they lose their compensation rights as well, because they pled guilty to a lesser offense. Yeah.
I have one question. As I understand, Innocence Project is a non-governmental initiative.
Yes.
Operated by the NGOs plus universities or schools. Are there any governmental initiatives like this, like wrongful convictions, commissions, or that the state is taking the responsibility for repairing its own mistakes?
Yeah, that's a very good question. Some of the states have established government organizations to look into this question, and they vary in their validity. In the North Carolina, that government organization is doing a very effective job. In Dallas, Texas, that's doing a very effective job. Colorado, very effective. They just exonerated somebody about 10 days ago. What we're finding in many of the other ones is a problem that it's run by the people who are invested in the system. They're not quite as open-minded. They think everybody's guilty. because it's staffed by prosecutors and the Attorney General's office. And what they end up doing is the Innocence Project say, we think this person's innocent, and the government commission investigates and says, we think they're guilty. So not all of them are effective. In fact, in the UK, the United Kingdom, they have the CCRC, Criminal Review Case Commission. And it's very much criticized by the Innocence Projects because the Innocence Projects believe they're too invested in the system. They're state actors, and that it's much more effective to have somebody independent, so you don't have that sort of tunnel vision problem. Yes?
You spoke about the false confessions. You spoke about the false confessions, and yet, as far as I'm concerned, in the US, if a person pleads guilty, he's not actually tried for the crime.
Right.
He's convicted.
Yeah.
So don't you think it's a serious flaw of the system?
Yes. Yes, absolutely.
Yeah, are you thinking about doing something about it, like a reform or something?
Yeah, I would love to do something about it. You know, we have so much resistance to any reform that, you know, it's been scratching, uphill, clawing just to get eyewitness identification reform and videotaped interrogations and things like that. It's a huge mentality problem. I mean, we over-criminalize things, we send too many people to prison, we send them to prison too long, and in order to make that bureaucracy and that mechanism work, which is a deeply flawed mechanism, in order to make it work, people are squeezed or pressured into plea deals. And so I want to make sure you understand that in the United States, when someone pleads guilty, they usually do not have a right to DNA testing later. Okay, because the court will say, well, you pled guilty, you admitted guilt, so we're not going to let you have the DNA. So all of these cases in the 300 people are pretty much just the people who went to trial, and only about 4% go to trial. So I mean, it's a serious problem. Now, one thing I can say to mitigate that is, the people who write our Innocence Project, most of them are not the ones who pled guilty. Most of the people who pled guilty are admitting they did it, but there's no doubt in my mind there are innocent people who pled guilty because they were pressured into it. It's a huge problem.
A ja chciałem się zapytać, jak w systemie sądowym amerykańskim są brane pod uwagę pomówienia współoskarżonego w sprawie, gdzie na osobę, która została pomówiona przez tego współoskarżonego, nie ma żadnych dowodów, ani rzeczowych, ani twardych, jak to się mówi u nas w Polsce, które mogłyby przemawiać za tym, że ta osoba jest winna. A konfabulacja współoskarżonego w procesie, później innych osób, wskazują całkowicie na niewinność osoby, która została pomówiona.
Yeah, another cause of wrongful conviction. I mentioned eyewitness identification. I mentioned false confessions. I mentioned junk science. Another one is accomplice testimony, where somebody committed the crime and they're giving leniency by the court to testify against somebody else. We call that snitch testimony. You have that in Poland, right? Where somebody's giving leniency in exchange for testimony. Many of these cases of people proven innocent, we now know that the snitch made up the story. It was false testimony. Rarely is there any repercussion for that. Usually the prosecutors do not charge them with perjury. They're completely left alone. Again, I'm trying to explain to you the mentality. This is not always the case, but most of the case, the prosecutors are still saying the person's guilty. They're refusing to acknowledge the evidence of innocence. And, you know, they'll usually oppose us in court, and the judge will be the one that says, this DNA evidence proves them innocent. And so you have prosecutors who are firmly entrenched in their position. And so they're not going to suddenly change and say, okay, now we agree he's innocent, and this witness was lying, so now we're going to go prosecute this witness for perjury. Right? So it shows again the mentality of the system and how human beings become so entrenched in their beliefs that it becomes very difficult for them to be objective. Now, could the wrongfully convicted person sue in a civil suit the person who made up the false allegation? Yes. However, the person who made up the false allegation is a criminal. He has no money. So what's the point of doing all that work to sue and get a $1 million judgment against a poor person who can't pay a dime? Are there any more questions? If not, I'll just say that in talking to Maria over the last couple days, you guys really do have an organization here on the ground that's dealing with these same issues and working hard and struggling against a system that's resistant, just as in the United States. So I hope as you move forward and you deal with their cases and you work with the Helsinki Foundation that, try to understand that these problems happen everywhere. So thank you.
Ja chcę to powiedzieć, że jednym z wniosków, jaki można wysnuć z znakomitego wykładu pana profesora, jest taki, że kwestie związane z wynikami badań DNA, jako z dowodem w sprawie, zrewolucjonizowały chyba w ogóle kwestie dowodowe i to nie tylko w dziedzinie prawa karnego, myślę, ale również w innych dziedzinach. W Polsce chyba, z tego co pamiętam, najwcześniej zaczęło się mówić o badaniach DNA, o wynikach badań DNA jako dowodzie w sprawach dotyczących prawa rodzinnego, w kwestiach związanych z ustalaniem ojcostwa, czy zaprzeczaniem ojcostwa. Ale nawiązując też do wypowiedzi pani, która jako pierwsza zadawała pytania co do wiarygodności tego rodzaju dowodu, myślę, że na to zagadnienie, tak jak zawsze można spojrzeć z jakiego punktu widzenia. Pan profesor mówił o tym. Pan profesor mówił o spojrzeniu z punktu widzenia tego skazanego, który chce udowodnić swoją niewinność, posługując się wynikami badań DNA, ale można też mówić o spojrzeniu z punktu widzenia władz, które prowadzą postępowania przygotowawcze, postępowania karne. Tutaj zawsze może pojawić się problem nadużywania tego rodzaju badań, właśnie i wiarygodności. Chyba słusznie też tutaj Trybunał Praw Człowieka w Strasburgu dosyć ostrożnie podchodzi do tych spraw. Jednej z takich głośnych spraw Marka przeciwko Wielkiej Brytanii skrytykował prawodawstwo Wielkiej Brytanii jako zbyt mało precyzyjne, pozwalające na zbytnią swobodę, dające zbytnią swobodę policji, służbom specjalnym w wykorzystywaniu, czasami być może nadmiernym, intencjonalnym wykorzystywaniu tego rodzaju dowodów. Ja chciałem bardzo podziękować panu profesorowi za znakomity, powtarzam, podkreślam, wykład. Dziękuję bardzo za przybycie, że chciał pan przybyć do nas, podzielić się swoją wiedzą, odpowiedzieć na pytania wszystkich przedstawicieli państwa. Dziękuję za obecność również państwa. Jeszcze raz bardzo dziękuję panu profesorowi.